Hey, this is Daniel O'Connor, lawyer in Vidalia, Georgia. I am today talking about personal property memorandums, which is something you may not have heard of. I want to talk a little bit about what those are. Before I do, I want to talk about personal property in general. Personal property is anything other than real estate. But what we're specifically talking about today is tangible personal property, so that excludes money. So what we're down to are items like your clothes, your TV, your furniture, your comic book collection, your baseball card collection, things like that, your jewelry. And most of estate planning focuses on real estate and money, but a lot of people can tell you stories about how some sentimental item was the cause of a lot of discord in their family. Who gets grandpa's college picture? That may not seem like a big deal, but if you've ever been through seeing that, you may know that it is a big deal to a lot of people. Traditionally in Georgia, you had two options about how to dispose of your personal property. You could give it away while you're alive, which I frankly recommend because that's a way for you to impart the meaning behind it. But the problem is you don't know when you're going to die, and you may not be ready to depart with your property. So that's not always a good solution. The other is to list all the items in your will or your trust if you use a revocable trust. The problem I've encountered working with a lot of clients is when they meet with me, they may know who they want to get some of their personal items, but they don't know all, or they may think of something later. And so everything doesn't get into the will or the trust. Our Georgia legislatures and the General Assembly have come up with a good solution. Well, they didn't come up with it, but they've just codified in Georgia that a new document that is dependent upon a will or trust is a manner in which you privately, not necessarily with your lawyer, can write down later an item of personal property that you want to go to a certain beneficiary without having to redo your whole will. And I call this a personal property memorandum, and a lot of other lawyers do too. Prior to 2001, which is when this law went into effect, it's codified as OCJ 53-4-5. These were not allowed. You either had to, like I said, give the property away while you were alive or specifically reference it in your will or trust. And because of the practical difficulties of maybe getting up to the lawyer's office to do it, or the lack of perceived importance of doing it, frequently didn't get done, but that's not really an excuse anymore. I'm going to demonstrate how using this document might work in a minute, but I want to point out a few key things. You can't just create a personal property memorandum to give your property away without creating an actual will, which you need to use a lawyer for. There's a few requirements for a personal property memorandum to be effective. So it must be signed and dated by the testator, which is the person who died. It must describe the item and the beneficiary for the item in reasonable detail. And it must be referred to in your will or in your trust. If it's not referenced in the underlying master document, then you can't use it. So don't just go create a list of who you want to get your items. If you don't have a will, it's not going to be effective. I want to show you how this works. What I've got here is from my own estate plan and my wife's estate plan. This actually goes with a revocable living trust, which owns all of our property, but it applies likewise with a will, which we also have a will. But it's something like you've got your will and you walk out of your lawyer meeting with a document like this that basically allows you to make small amendments in the future without having to come back and redo your whole will. So This one says, I actually grabbed the one from my wife, not me, but it says, I, Reese O'Connor, signed the document that established, you know, the trust. In my case, there could be a will if you don't use a trust. And the trust refers to the disposition of certain items of tangible property, may be recorded in a memorandum, like this one. You can see this one's blank, but I'm gonna write something in it. So I wrote in here a description of my tangible personal property, and I wrote, you may not be able to see it, I put my laptop. And then the person to receive it, I wrote June Smith. That's a made up person, but just giving you an example. And it's as simple as that. And then she would have to sign and date this. And she would put it with her will, or trust as the case may be. And it's incorporated in that document without you having to go back and go through all the formalities of creating a new document or an amendment. So that's really helpful. It's a great tool. It wasn't available in Georgia until 2021. So if you're working on an estate plan or thinking about it, keep this in mind. I hope you found this video helpful. I'll probably do some more about personal property and how to handle that, because it's very important. If you found this content helpful, I'd suggest subscribing. You can go to our website and subscribe to our newsletter so that you get frequent updates about our firm and the type of services we're offering. And even if you don't use our services, hopefully the information we're providing is helpful to you. So take care and have a good day.